So our next speaker is Dr. Chinthaka Liyanage. Dr. Liyanage is currently lecturing law, faculty of law at the University of Colombo, and he began at the university in 1999. He is an attorney at law of the Supreme Court of Sri Lanka and has been so since 2000. He obtained his Master of Law degrees from the University of Melbourne in 2006, with a scholarship granted by the World Bank. He earned his PhD in law in the area of international commercial arbitration through the law school at La Trobe University in Australia in 2013. He was a recipient of the Australia Leadership Award and was granted by the Australian government to allow him to pursue his doctoral study at La Trobe University in 2012. Dr. Liyanage has published several articles in peer-reviewed journals, presented several papers in international conferences in several aspects of online international commercial and consumer arbitration. He is currently teaching commercial law-related subjects for undergraduates in faculty of law, working as a course director of the subject entitled International Commercial Arbitration, offered in the LLM program in 2013-2014 by the faculty of law. His areas of expertise are international commercial arbitration, commercial law, and information technology law. Everyone, please welcome Dr. Liyanage.
Thank you, distinguished Chair. Ladies and gentlemen, my topic is a bit lengthy one, but I will reiterate it. Enforcement of an international commercial arbitration award through the government-sponsored court in the form of a foreign judgment. A survey of positive elements. Of course, my focus is on the enforcement aspect of decision made by dispute resolution mechanisms. So that is crucial. That should be addressed and strengthened where there are, or in cases where there are some drawbacks or problematic areas. So one specific area I identified is enforcement of foreign arbitral awards, or an award delivered in a foreign country, which may come into Sri Lanka in the form of a foreign arbitral award, or it may come into Sri Lanka for the enforcement purposes as a foreign judgment. Foreign judgment is based on that particular foreign arbitral award which was delivered in that particular country. So when there is a foreign arbitral award confirming a foreign arbitral award, we have a question to address. Question is whether we have a supportive legal framework to enforce such kind of foreign judgment. So keeping that particular element in my mind, I will again elaborate the particular area. Enforcement can take different forms. One would be actually a consensual enforcement mechanism. Consensual enforcement mechanism includes parties who are subjected to a final outcome, who are liable to pay a certain amount of money, then he will comply with that particular outcome. If it takes place, then the matter is over. But if there is a mandatory dispute resolution mechanism, final decisions are mandatory and carry res judicata effects, then parties have no choice. If one party does not comply with the final outcome, he has to go through a mechanism set up by the government. Then, for example, if parties are subjected to arbitration, the final award can be enforced as a foreign arbitral award if it is a foreign arbitral mechanism through the government which are parties to a particular convention. That is in 1958, recognition and enforcement of foreign arbitral awards. Second mechanism is if those parties or one party want to get their final arbitration award as a foreign judgment, then there is a mechanism for that. That is called enforcement of foreign judgments. But the question relates to the specific point that these two enforcement mechanisms I mentioned last, third and fourth one, a foreign arbitral award, which is delivered in a foreign country, and either both parties or one party get a get a judgment from that particular jurisdiction, and whether it can be enforced through the New York Convention, or should they go through the legal framework designed for the enforcement of foreign judgments. Then there is a question to address there. Keeping that particular element again in mind, I organized my presentation under several themes. First one, problem, research question, hypothesis, findings and discussion. I will go through quickly the problem to the problem area. Problem through the lens of literature, we can see when there is a foreign arbitral award and disregarding that particular arbitration award, there can be a foreign judgment based on the same facts and issues of that particular award. And there can be another one confirming, there can be another one based on the validity of the arbitration award or the foreign arbitration award given by that particular, delivered in that particular country. Third problematic area recognizing if there is a foreign judgment, merge in the final foreign arbitral award. In all these cases, this Commission of the European Commission has recognized that areas are now not, they have some problematic area. We need to address those elements. With that view, again another writer has succinctly expressed that how foreign judgments confirming arbitral awards relate to the original award. He recognizes the fact that this relationship affects the litigation strategies of parties in actions to recognize and enforcement arbitral award. This issue deserves closer inspection than has been devoted to it. So now it is clear that this is the area we need to address. So the problem we can see now. So the next thing I wanted to move to is, can the enforcement of foreign judgment confirming foreign arbitral award be made effective? Of course, my argument is the enforcement of such a foreign judgment can be made effective by bringing required amendments to the problematic areas of the existing reciprocal enforcement of foreign judgment related legal framework. That is a legal framework developed in each country of the world. That is something my focus is, of course, when there is a foreign judgment based on a foreign award, then it has to come through national laws, that is reciprocal enforcement related legal framework. In Sri Lanka, for example, we have in 1921, which is a big old one, which regulates that particular area. But my research is, of course, we have a legal framework, but when there is such a foreign arbitral award, foreign judgments based on foreign arbitral awards, existing New York Convention based enforcement mechanisms has problems, which does not embrace that particular area black and white. As a result, it opens up, New York Convention opens up parties to use foreign judgment as an effective enforcement mechanism for the enforcement of their final award.